Okay, it's noon, so we're going to get started. Good afternoon, everyone. Welcome to the 20th Annual Cleveland Metropolitan Bar Association Labor and Employment Conference. Today is our first session. We will continue meeting virtually for the next 5 weeks after this. And at noon on Wednesdays, if you're not signed up, please do so. You can ask questions through the Q&A function in Zoom, so please feel free to do that and we'll get to those questions. So today you'll hear from Rebecca Bennett and Rico Barrera. They're attorneys in the Cleveland office of Ogletree Deakins, a global labor and employment law firm. Both Rebecca and Rico are labor and employment counselors and litigators. An area they frequently practice in is unfair competition and restrictive covenants, both enforcement and defense. That means they have represented both plaintiff and defendants, including individuals and companies, in federal and state court, restrictive covenant counseling and trials. Today, they will lean on their experience and talk about restrictive covenants in Ohio and elsewhere in the United States and expected trends within the law over the next short period of time. Anyways, so take it away.
Excellent. Well, thank you, Jennifer, and thanks to the CMBA and to your leadership for inviting Rebecca and I to speak today. And for being nimble in what is obviously a very interesting time in moving the format of our conference to this version over the next couple of weeks. I'm really excited to get it started and looking forward to interacting with you all. So the area of restrictive covenants and unfair competition is one that is becoming more frequently litigated. And as that trend grows, we think that's an important area to be familiar with as members of the labor and employment bar. So what I love the most about restrictive covenant litigation are also the things that make it the most frustrating at times. It is an extremely fast-paced kind of litigation. They're often emotionally charged because they deal with deeply held relationships. At times, portrayal can be involved. These are some of the more interesting aspects of litigation, but also, again, some of the most frustrating parts of it. These are the kinds of cases where a client can call you in an absolute panic and they just breathlessly drop an array of issues that they need resolved immediately. That often involves the need for immediate injunctive relief. So you have limited time to get up to speed, and every day matters, regardless of what side of the lawsuit that you're on. And often success is measured very early on in the proceeding at the preliminary injunction stage. And so we're talking just a matter of weeks at times. When we approached Jennifer about presenting this particular topic at the Labor and Employment Conference, this was obviously before the time of COVID-19. So it was just sort of a twinkle out there. We were starting to hear rumors of things in China and only just starting to understand its potential impact globally in the United States. And obviously things have changed a lot since then. But I hope that this is an opportunity to talk about something that is not COVID-19 related, and maybe that's a breath of fresh air. I know for most of us that's 24/7 right now. And so hopefully it's a good opportunity to talk about something not COVID-19. But of course, COVID-19 really does impact everything. So there are still some aspects of COVID-19 that will impact this area of law. So Rebecca and I will touch on that generally. Our goal for today is really to provide you with information about the different types of restrictive covenants that are out there within the employment context, how they work in Ohio as compared to other states. And we also want you to be aware of those COVID-19 considerations, as well as trends both within Ohio and nationally that we expect to continue seeing within this space, and that honestly may be accelerated in some ways because of COVID-19. So we'll get into some of those specifics as well. So the term restrictive covenants is a fairly broad term, and some of the most popular types of them relate to non-compete agreements or non-solicitation of customers, or the prohibition against disclosing confidential information. This is stuff that is central to the employer-employee relationship and is one of the things that immediately pops to most people's minds when they think about restrictive covenants. Obviously, some of the most frequently litigated types of restrictive covenants as well. But it also extends to other things, which would include things like inventions that an employee may come across during their term of employment with an employer. It can also extend to things like prohibitions against soliciting coworkers. So if one coworker were to move to a new area of employment, prohibiting them from reaching out to their coworkers to come join them at that competing employer. Really, all of these things have one thing in common, which is that they capture some of the most vulnerable parts of the employer-employee relationship. Many of these things are impacted by the industry within which the employer and the employee operate. So they can get, some of them are very
Okay, it looks like we lost Rico for a moment, so bear with us as we figure out some of these technical things. Thank you.
This is Rebecca. Jennifer, is it okay if I take this up while we get Rico back?
Go ahead, Rebecca, if you can. You're muted.
I'm going to see if I can't share my screen too, so we can get the PowerPoint back up. So let's see. 1 minute. And all right, that's not the right screen. Jennifer, can you see the PowerPoint yet?
We had it for a moment, Rebecca, and then you X'd out of it.
Okay.
So if you want to try sharing your screen again.
Thank you. Okay. Okay, can you see it now?
Yes, we can.
All right, great. Okay, moving right along. So what Rico was going to say next was he was going to talk about the steps to enforcing non-compete agreements and non-solicitation agreements, or restrictive covenants, the general term. You know, the first thing that we advise our clients to do is you have to draft a reasonable, enforceable restriction in the first place. That covenant then has to actually be effectively signed. One would think that that would be easy, but in this day and age where there's sometimes wet signatures and electronic signatures, we find sometimes that our clients have obtained an electronic signature, but they haven't done it effectively or within that state's law. So that's an important step. Also, if you are an employer and you want to enforce a restrictive covenant, you ought to have a record of having consistently enforced that agreement. So if you've got non-competes and non-solicitations and you've let them go, you've let other people leave and go to competitors and you haven't enforced those, that will be held against you in litigation. So that's pretty important. That's why it's a good idea to have a regular practice of sending those cease and desist letters out. which is the next step. Reminders and cease and desist letters. That's a first step before you get to the courthouse to file a complaint alleging a breach of a non-solicitation or a non-compete agreement. And when you do go to court, what we typically do is start with a temporary restraining order request. So we would file a complaint, a verified complaint, and a motion for a temporary restraining order and a preliminary injunction. And it's a lot of fun because there's all sorts of papers and pleadings that you have to get ready to file all at the same time, and you got to do it right. You don't know who your judge is going to be, and then usually you have to act very quickly to set up a time to speak with the judge. Usually that's done in person, but the last one I did a couple of weeks ago was done over the phone because of the fact that we can't get to the courthouse now. There might be some situations where rather than asking for a temporary restraining order, you skip that step and instead you ask for a preliminary injunction. And we've had to do that in cases where the client hasn't engaged us right after the employee departure and the violations begin, and therefore we're not going to be able to show that there's irreparable harm because they've waited a while. And there could be other considerations for why you wouldn't want to seek a temporary restraining order. So that's an option that we always think about each time. And then the next step to enforcement is simply seeking damages. What is it that you're going to ask for besides injunctive relief? Have you already experienced some loss of business for which damages are quantifiable now, or they may be quantifiable sometime down the road in the lawsuit? So let's talk a little bit about Ohio-specific considerations. But before I do that, do I see that Rico made it back?
I made it back. I apologize for the technical difficulties.
No worries. That's not stressful at all, is it? We'll take a breath because this is my slide, so we'll let you get back into it in a couple of slides. So in Ohio, there is a 45-year-old case called Raymond v. Van Valera. This is a case from 1975 that is still the leading case on what you need to do in order to have an enforceable restrictive covenant in the state of Ohio. So there's lots of nuances that have developed in courts and in cases over the years, but this is the one we always go back to, and this case is always going to be in your brief, whether you're prosecuting or defending a case. And the basics of Raymond is simply to say that in order to have a non-compete or a non-solicitation in the state of Ohio, you've got to first have a legitimate protectable interest. So what is it? Typically, it's going to be the fact that you have some confidential aspect of your business, some trade secrets perhaps, or maybe it doesn't rise to that level, and that this employee that you're trying to restrict had access to that, had meaningful access to it. Now, in some courts and with some judges in the state of Ohio, this is sort of a pro forma requirement. They simply assume that any employee who has a restrictive covenant will probably have a protectable interest, but not every judge. We can tell you that for certain, that is something you shouldn't overlook, and you should be ready to have proof to show exactly what your legitimate protectable interests are that justify having this restriction. And then the case goes on to set forth the factors that are written here on this slide. These are all of the factors that a court will consider to determine whether, first of all, you've established your protectable interests. The second question is, are the restrictions reasonable? Are they too broad? Are they too broad in geography or in time or in any of these other factors? Now, notice that these are factors and not elements. So you don't have to meet each and every one of these in order to show that your covenant is reasonable. We'll talk about some of these in a little bit more detail, but they include things like time and space. In conjunction with somebody who's involved in sales, were you the sole contact of the customer, or did the customers have access to lots of people in the organization? We're going to look at whether we're seeking to restrict unfair competition versus ordinary competition. Looking at whether the covenant seeks to stifle the inherent skill and experience of the employee. Perhaps you have an employee that came to you with all the skills and experience, and they didn't develop that from your employment. You may have a difficult time restricting that person from moving on. So let's move on to the next slide. I want to mention a couple of things too that are specific to Ohio. We also have a state law protecting trade secrets. So we have now, as of, I think maybe 4 years ago, we have a federal law that protects trade secrets called the Defend Trade Secrets Act, but we've always had one for a long time in Ohio called the Uniform Trade Secrets Act. And it's very similar to any other states that follow the Uniform Trade Secrets Act. And it's also incredibly similar to the Defend Trade Secrets Act. There's very, very small differences. But what that law does is even if you don't have a restrictive covenant, none of your employees are allowed to leave and then use your trade secrets, take your trade secrets, misappropriate your trade secrets. So in many of the cases that we handle, we include claims for breach or misappropriation of trade secrets under the state law. There's also an Ohio Deceptive Trade Practices Act. Doesn't come up as often. And this is involving more false statements when it comes into this context. But there's an advantage to using that law because it's got a fee shifting provision right in the law. So that's helpful if you can weave your facts into that particular law. And then, although it's not listed on this slide, another consideration is certainly any state law, common law claims, things like tortious interference with business relationships. That's often something that is added into an unfair competition lawsuit. All right, moving on. We wanted to get into more detail on time limitations. Rico, are you still there? All right, I saw his picture come in and come out, so I'll continue on this until we get him back. So how long is too long in the state of Ohio? It depends. It depends on the judge that you get. It depends on the court that you get. I wish I could tell you that there is uniform enforcement of these rules from court to court and even courtroom to courtroom in the same courthouse, but there is not. In Cuyahoga County, we do have the advantage of being able to file these cases on the commercial docket. And so there has been a little bit more consistency because we've got a limited group of judges that are hearing these types of cases. But here's what the case law says. It says that, 1 or 2 years is probably going to be okay. I always tell my clients, if you've got a 1-year non-compete, you're almost certainly fine, unless you have some very strange and onerous restrictions other than the time frame. But there's cases that say a 2-year non-compete, non-solicitation is fine, and plenty of cases that say that 1 year is fine. Industry factors are often a part of that. Rico, do you want to add anything to that one on time limitations?
No, I think that the key consideration is it's really going to come down to the facts and circumstances of that specific industry. There are lots of fact patterns in which a shorter restrictive covenant might be most appropriate, and there are lots more where that would support a 1 to 2 year time limitation.
Great. And one thing I'll add too, you probably all know this as lawyers, but just in case you don't, we can't have non-compete agreements as lawyers. So there could be some professional restrictions like that could apply to certain types of jobs. Okay, Rico, you want to take over on geographic limitations?
Yeah, absolutely. So, just like time limitations, geographic limitations will be heavily influenced on industry type and the specific situation. So, for example, salespeople within 2 different businesses might actually be viewed differently by the court depending upon the type of product that they sell, how competitive the market is, right? So on the one end of the spectrum, maybe you could think about something like an ice cream shop, a restrictive covenant that might apply to a franchise. The geographic scope and the nature of the competition with that industry might be different than something like maybe a very niche medical market in which the market truly is national in nature, right? And so that would support a broader geographic limitation. So it will be very fact specific and industry specific. In general, Ohio courts really measure geographic radius by straight line distances as the crow flies, rather than by how long it might take to drive somewhere, for example. That's the preferred method of measuring those things. And ranges can really vary from a few miles, like perhaps within the ice cream shop kind of scenario. maybe it's truly a neighborhood-oriented market, and a few miles is really the extent of the reasonableness of that restriction. It could extend all the way to statewide restrictions, including all of Ohio. It could include regions like the Midwest, and even in some instances, like the case that we have cited on the slide, even nationwide restrictions can be appropriate. But as we said all along, it truly depends on the facts. And the broader that geographic restriction gets, the more that you need to have evidence to support the basis for that kind of restriction. So, for example, a nationwide restriction would truly take a lot of support and understanding why in that particular industry a restriction like that and that restraint on competition would be justified.
Sure. And by way of example, we had, for some reason, we get a lot of dentist cases in the non-compete world. I don't know why that is. But in dentist cases, because of the nature of the industry, the restriction is probably going to be something like 5 to 10 miles. And the issue about the crow flies, a radius, is really important, especially depending on whether it takes highway travel to get somewhere. And so that's something that's often very much argued in these cases, and something that you'll want to be prepared, depending on which side you're on, to argue with the judge. All right, moving on to the next slide. Some more Ohio-specific considerations that we wanted you to know about. Rico, is this one yours to take on?
I could take on this one if you want to pick up the next one.
Sure, great.
So as we talk about specifically Ohio, consideration can include things like money or an additional job responsibility that comes with the promotion or something along those lines. But quite simply in Ohio, continued employment is enough consideration to justify a restrictive covenant in terms of the employer-employee relationship. So there can be instances maybe where a restrictive covenant wasn't in place with a particular employee and the employer now seeks to impose one. The employer is not obligated to do anything above and beyond continuing to employ that employee to make that restrictive covenant applicable to them. That is not the case in other states, and I know Rebecca and I will talk about that. So that is an Ohio-specific nuance, but an important one to think about.
Let me cover reformation and blue penciling.
Sure.
So those are very similar, slightly different concepts. You might have heard of it before, but blue penciling, it's kind of an old term. We would call it redlining, I suppose, today. But blue penciling means if the judge decides that the restriction is too overbroad or isn't reasonable, is the judge simply going to say it's not enforceable, or is the judge going to make some changes to it? So under the blue penciling doctrine, the judge can actually cross out some portions of it. A similar concept is reformation or modification. So that's not just cutting things out of it, it may be changing the restrictions altogether. And I find that most judges are very much willing to do that. They want to do that, and they use it as a way to try to get the parties to reach an agreement. You know, that the parties understand that the judge may modify the restriction, and so the discussion of the temporary restraining order or the preliminary injunction may lead into the judge previewing what they intend to do, and then the parties quickly resolve the case once they know what the judge is going to do with the case. I already told you that enforcement differs from court to court and judge to judge. But one thing I want you to know as practitioners is that the equities of the case should never be ignored. There is always a story to tell in a non-compete case, in a non-solicitation case. And it's not rocket science. It's usually a villain and the good guy. And whoever you're representing, you want to have the good side. And so you want to draw out those facts that show that your client is in the right, they're in the wrong, they're being unreasonable, you're being reasonable, all the things that you can draw together to show that the equities weigh in your favor. That's really, really important. Even if it's not written in the law, it's often what wins or loses a case. Okay, I know, Rico, you were going to cover this one, right?
Yeah, so as we expand our scope and think about how restrictive covenants are treated in places outside of Ohio, we can think about them in big categories, right? So some states just simply don't permit them. California, North Dakota, Oklahoma, those are examples of that, California being a really popular example, one that people interact with frequently. And in those states, they're simply just not enforceable. So that's important to consider, especially if you're working with an employer that has offices or a presence in other states, or if you're representing an employee who is maybe working for an employer that's based in a different location. Those are things to think about. The other bucket we would put them in is some states don't prohibit them, but they strongly disfavor them, whereas other states liberally permit them and view that as an okay restriction on business. Some states use the blue penciling doctrine that Rebecca mentioned, which is excising terms from a covenant. Other states use something called the red penciling doctrine, which is something that Rebecca mentioned, which is rather than sort of line item deleting certain terms within a restrictive covenant, simply striking the entire covenant if something about it is not appropriate under that state's law. Some states don't have a specific doctrine, so it's tough to tell what a specific judge or court would determine when reviewing a restrictive covenant. So New Mexico and Utah are two examples of those. But overall, the broad majority of states use the Reformation method in a way that is similar to that of Ohio. So we've tried to call out some of the specific different states that fall into different categories, but many states use the Reformation method.
All right.
So other than those kind of broad categories of ways that states treat restrictive covenants, a lot of states just have really independent and unique nuances. And so the next two slides are going to depict some of those. It's by no means an exhaustive list of all the different types of nuances across the country, but ones to think about that bring out some concerns that you should maybe have on your mind if you find yourself in this area where Ohio law isn't the law of the case. So for example, in New York, a covenant is not generally enforceable if the employee is terminated without cause. And that I point out because that is something that could be incredibly relevant, especially today in light of COVID-19, right? If a lot of people are being laid off or there are various kinds of reductions in force that have nothing to do with the employee's performance. So you want to think about, what does that particular state have to say about the enforceability of a covenant when just cause isn't part of the issue.
We go back to Connecticut.
What's that? Oh,
Connecticut, yeah, that's where I'm at now.
My apologies. I think I jumped ahead there. So in other states, like Connecticut, like all the states actually on this particular slide, continued employment may not be enough consideration to enforce a restrictive covenant, right? So in those states, it wouldn't be appropriate for an employer to apply a restrictive covenant after the employment relationship has begun. So in Connecticut is a good example of this. Pennsylvania is another good example of this. Those types of restrictive covenants need to either be supported by additional consideration, whether it's a promotion and an increase in pay and an increase in responsibility, or they need to begin at the inception of the employer-employee relationship. It can't be something that's added on as an additional term of employment without some additional consideration. And then, sorry, would you mind, if you jump ahead. Another interesting example is Florida, where they don't have time limits codified, but they do have presumptions with respect to reasonableness of restrictive covenants. So if it's something that's less than 6 months, it's presumed to be reasonable. Obviously, the evidence might change that particular outcome in a court. And if it's over 2 years, then it's presumed to not be reasonable, again, subject to evidence that might rebut that presumption. The one other thing I would point out, we talked about California being a state that doesn't enforce restrictive covenants. That's true. The one caveat to that is California still does recognize protections against protections of trade secrets and confidential information. So there can be terms within employment contracts that relate to not disclosing trade secrets, things like customer lists or sensitive information. Those things are still protected under California. It's really the competition aspect that is not protected.
Great. Okay. So I wanted to talk a little bit about that, because if you've got some of these states that have very different requirements and you're advising your clients about drafting, then you've got a big decision to make about what choice of law you want to include in your agreement. So in Ohio courts will enforce an agreement that has an Ohio choice of law provision, but so will Ohio courts enforce an agreement that has a choice of law provision from any other state. And choice of law provisions can be overridden in some cases. That's not easy to do. In Ohio, we follow the restatement of conflict of laws rule. But the best way to ensure that you have transparency and clarity over which law is going to apply is to write that as specifically as you possibly can in the agreement. Sometimes we see provisions, I saw one just this week that said, the choice of law will be the state in which the employee was domiciled on his last day of employment. So the state's name isn't written in there, but that's what was in that agreement because it was a company with nationwide employees. You know, because in addition to choice of law, you also have to consider venue. You can't just pick Ohio if there's virtually no connection to Ohio in the case. You still have to meet that venue requirement. You know, the law school exam we all had about all the factors that come into place to determine whether a court has jurisdiction and whether venue is appropriate. You still have to meet those threshold tests. So for instance, if you have a case where you've got an employee that lives in Utah and the company is based in Wisconsin, it's unlikely that a court is going to enforce an Ohio choice of law provision. And you may say, how could that possibly ever come up? It comes up a lot in acquisitions. So one company has acquired a company, they have all these old covenants that have their state's choice of law, but that company isn't doing operations in that state anymore. So you may end up in one of these strange situations where you're fighting over which state's law is going to apply. So this is what that restatement says. It's section 187.2 of the restatement. And so if a choice of law selection hasn't been made in the agreement, then the Ohio courts will apply the law of the state that has the most interest in the state, unless it would be contrary to a fundamental policy of a state that has a materially greater interest. We're handling a case on this very topic right now, so we've gone over and over this restatement, and it seems very clear, but you know, it's interesting to see how judges will apply this differently. And I think what happens sometimes in these cases is judges have an idea of how they think the case should go because of the equities, and then you sort of massage the law to fit what you want. If there's any judges listening to this, they would probably vehemently disagree with that. And I'm not suggesting that any judge is doing anything wrong. It's just that the application is so not uniform that sometimes it gets to be a little bit frustrating as a litigator. Okay, so both Rico and I wanted to talk a little bit about this. So what about restrictive covenants during this COVID-19 crisis? And I'll get us started and simply say that so far I've had to file one since March 16th when we kind of shut our doors and started to work from home. And we really struggled and did a lot of hand wringing about whether, you know, the judge was going to be mad at us for coming in during a time like this, a global pandemic, and being worried about our little restrictive covenant. And I can tell you that at least in Cuyahoga County on the commercial docket, we were treated with just as much seriousness and respect as if we had made the claim at any other time. So in other words, nobody belittled our claim, saying that it wasn't important enough considering the pandemic. The other thing that we were worried about would be, you know, does the employee have an argument to say, you can't restrict me from this line of work because there's no other jobs available. You know, in this climate, we have such huge unemployment, you know, reaching 10%, you just can't put me in a job market and therefore I can't find another job. And that actually is a real consideration and something you should think about before filing any of these claims. Rico, what can you add on that? I know
you know, something to think about too will be the impact, and this is not reflecting on the slide, but it made me think, this could have an impact on the way in which damages are viewed moving forward. Just thinking about, I think at the last tally, about 30 million people are now unemployed, right? So it's really hard to find a job right now, and a lot of people don't have jobs. And it could be, too, that people subject to a restrictive covenant may not have been, who have left employment, may not have had employment had they stuck around because of COVID-19. So it's going to impact the way in which we think about damages, although we don't really understand yet exactly how that will all flesh out, but it's something to think about.
Sure.
But, go ahead. I was just going to say, at a broader level, just thinking again about the fact that you have 30 million people who are newly unemployed. What that means is you just have a huge amount of people who no longer have a job who may have been subject to a restrictive covenant. So it may be that there will be a wave of these types of cases as people start to find new jobs in the coming months, hopefully as the economy starts to reboot, and people move on maybe to competitors of their former employer because their former employer isn't hiring yet. And then you see enforcement or application of these restrictive covenants. And I think the economy plays another role in this, which is that as things continue and companies look to recoup some of the revenue that they've lost over the last couple of months, there's going to be increased competition. People are, and so what that may mean is that employers may be more likely to more aggressively enforce their restrictive covenants in the event of an employee who's moved on to a competitor and who's now working with some of their former customers, right? So it could mean that employers are more likely to push these kinds of things. The other really broad and big consideration here is that a lot of people who haven't lost their jobs are working remotely. I know Rebecca and I fall into that particular category, and I'm sure a lot of you do too. And there's actually just an article about this in Law 360 a couple of days ago about the fact that people are working remotely means that they have an unprecedented level of access to confidential information. And not only do they have an unprecedented level of access, they have an unprecedented level of lack of supervision over that access. And so when you put those two things together, it's much easier, I guess if I think about it cynically, it's a lot easier for an employee to take and potentially misappropriate confidential information and use that against their former employer. And I guess to put it back on the employer, something that may not be happening now that would maybe happen in better economic times, given the volume of layoffs and RIFs and things of that nature, exit interviews may not be happening with the degree of specificity or frequency that they would ordinarily be. And so what that can mean is that there could just be confusion about what about the restrictive covenant will apply to that particular employee. It could be that they continue to retain confidential information that they would have otherwise gladly have given up, but because there was no exit interview, there wasn't a prompt to collect that kind of information. So you can see there's sort of a cascading effect that this volume of layoffs and RIFs could have in this particular space. Rebecca, do you have anything else to add to that?
That's good. That's good. I think the bottom line is you ought to be prepared to answer questions about how COVID-19 and frankly the subsequent economic recession impacts your case. That's something that you ought to talk with your clients about and be ready for. All right, so let's move to our next topic is trends. What are we seeing? What will you see coming up? So I want to talk about a few of these. First of all, increasing efforts to limit enforcement against low wage earners. So it's no secret that non-competes are disfavored among low wage earners. And typically the reason is because you haven't established a protectable interest. So if I have a client that has business operations in which they employ folks from a wage range of $15 an hour all the way up to hundreds of thousands of dollars, and they want to do a uniform non-compete, non-solicitation for everybody, we usually have to put the brakes on that and say, perhaps what we can do is a uniform non-disclosure of confidential information. But if we're going to have greater restrictions like a non-compete or a non-solicitation of customers or employees, we really do want to tailor that to the right folks. Another issue that's coming at us from other states is an advance notice requirement. So it's almost like you know, when you have one of those Fair Credit Reporting Act requirements that require you to make a plain notice to folks so that you're not sneaking these restrictive covenants and other policies or agreements, and they leave employment and they had no idea that they were restricted. So we're seeing that in a lot of cases where you've got to have advance notice, it's got to be plain, and you've got to be able to prove that we showed the employee that they were going to be subject to these restrictions before they either signed the agreement or before they became employed. Rico mentioned some states that are now codifying geographic and temporal limitations. I don't know if that's going to happen in Ohio anytime soon, but it's certainly a trend. And also, I want to go down to we'll talk a little bit about this in another slide too, but there's this growing acceptance of the janitor rule. So what's the janitor rule? The janitor rule is a rule that says you can't have a non-compete that restricts me from doing anything for a competitor. So I should be able to, if I'm the head of research and development at DuPont, I should be able to go to DuPont's biggest competitor and be the janitor. That's the janitor rule. So in other words, you can't restrict me from doing all sorts of different kinds of jobs. It should be related to the function I had with your company. And lastly, we're seeing lots of issues regarding social media. The biggest one is when you promote yourself on social media, when you go to join the new employer and you try to get new business. One way that we do this, either directly or indirectly, sometimes is on LinkedIn. You know, that's the way that I keep up with where my friends are moving to and moving from, is I get a notice on LinkedIn that they changed jobs. Well, does that individual have a non-solicitation agreement? Could it be argued that by informing the rest of the world that they're with this new company, that they're indirectly soliciting business? Sure can. There's lots of cases coming down on this, and this is evolving, you know, because 5-6 years ago, sometimes you'd get a judge that really wasn't familiar with LinkedIn. I don't think that's the case anymore, but it was just something that wasn't used in the way that it even is used today. So we're seeing a lot of that. So what does that mean to you as a practitioner? You got to check your client's social media activity, or you've got to check the plaintiffs, defendants, whoever's on the other side, social media activity. And that's including companies too. I can't tell you how many times recently we've had a defendant say, or a plaintiff say, hey, we've got all these trade secrets and you stole them and you have access to them, and we've got this very proprietary process. And I go on YouTube and I search the company and there's their process. They've got a video and it's for the whole world to see. And so we've used that as evidence in trial to say that you don't have trade secrets that are protectable, or you don't have business information that's protectable. Here, I want to talk a little bit more about low wage earners that I mentioned. Here's where we see the trend coming in states like Illinois. Illinois is becoming very restrictive covenant unfriendly. It's not quite California, but it's definitely becoming harder and harder. Maine, New Hampshire, Oregon, Washington, Maryland, things are tightening up in each of those states. And then we mentioned the advance notice requirement. So that's something that if you're requiring for a new employee, ought to be in their offer letter. In fact, the restrictive covenant could be in the offer letter itself. That's fine. But if it's a separate document, I would include that in the offer letter as well. All right, Rico, is this one yours?
Yeah, this one's mine. So as Rebecca mentioned, I think we're unlikely to see a codification of geographic and temporal limitations in Ohio, at least as of right now. But it is a trend that we're seeing in some states, and you might continue to see increase, because it touches on that tension of, you know, these things can be very fact specific and they differ industry to industry, and what comes with that is uncertainty. It's something that Rebecca mentioned. In this space, there can be uncertainty about what will and will not be deemed reasonable by any court in any given circumstance. And that's sort of the nature of these cases. And codification of those limitations can help to, you know, give predictability and certainty to both employers and to employees, so that they understand what they're up against. Obviously, that can cut both ways, right? That doesn't always accommodate unique industries. There's a benefit to thinking about things on a case-by-case basis, right? But I think we're starting to see a trend where people want to see a little bit more certainty, and some states are giving that with codification. And the other thing, we touched on this towards the beginning of the presentation, is a heightened requirement to demonstrate irreparable harm. You know, pretty much every one of these cases is going to rely on some kind of emergency injunctive relief, whether it's a TRO or a preliminary injunction. And a party's going to have to show irreparable harm in one way or another. But I think what you're seeing is less, maybe more of a requirement from courts on a state-by-state basis, that there be really direct evidence of what that irreparable harm is. And it's not just the employer saying, you know, this employee has really important information and we're going to be damaged because of it, right? Showing exactly what is the scope of that damage, what is it specifically about that employee's knowledge and circumstance that would really harm the employer, and how can we, is there a way for us to quantify that, or what can we extrapolate from that to try to get a good sense as to how big that damage is going to be. I think you're seeing more courts require that kind of specific evidence, and it then becomes incumbent upon the practitioner to make sure that you're gathering that information, asking those questions of your client, and putting that forward when you do seek that emergency injunctive relief.
All right. Okay, delaying effective dates of restrictive covenants. So, you know, we see these a lot in our agreements where there's a question as to when the restriction starts. You know, the easiest and most obvious time and most common is at the end of your employment. But we've got lots of provisions that say that's going to be delayed and told until the court issues a ruling on enforcement. So if I have to go to enforce this agreement and incur the cost of that, I, as the employer, want to extend out the terms of that restrictive covenant. And there are some jurisdictions that don't really like that. And frankly, lots of judges don't like that. So even if it's written in your agreement, it's quite possible that a judge will say, no, I'm only going to extend this restriction from the time of last employment rather than from when I issued a ruling on this. And then we talked about the janitor rule already. So that's just something to keep in mind. And that's a great way to try to resolve a case, you know, because I would say, I don't know what the stat is, we probably should have pulled that before this, but just in my experience, maybe 75% of these cases resolve either before the preliminary injunction hearing or around the time of the preliminary injunction hearing. And some of the ways that they get resolved are by saying, you can do these 3 things, but not these 4 things. So we figure out what is it that is tolerable for the new employer and what is it that's really important to the old employer. So we don't actually restrict the person from working for a competitor, but we outline exactly what they can do and what they can't do. Another way to do that is to parse out which customers. So there's lots of different ways that these cases can and frankly should get resolved. This litigation is expensive. It can be very expensive, and the costs and fees rack up very quickly. So any of you who do any of these cases, I'm sure you say the same thing. Before you file one, I always want my client to know it's going to cost X in the next 90 days. And if they can that number is palatable to them, then great. Then we move forward. But if that's a shock, then maybe we think about other possibilities or other ways that we can try to address their particular problem. All right. I talked a little bit about social media, but Rico, you want to add to that?
Yeah. You know, one thing I would add is that this is a growing area of case law. Obviously, it's going to become more and more frequent as we as practitioners, or as employees, more frequently use social media in a professional context. You know, I think what we're trying to do is really draw the line of what is communication that's directed towards a customer or a coworker in the context of a non-solicitation agreement, and what is just, you know, advertising that isn't directed towards a particular person or entity. And that can be a really tricky line to draw. And that's one that I think we'll see continue to be drawn over the next next year or two and beyond.
Great.
So with that, hopefully that gave you a flavor of what to know about restrictive covenants under Ohio law, how it fits within the context and the framework of other states across the country, and some trends to expect over the course of the next few months to the next year or two, especially as we move into this post-COVID, hopefully soon, post-COVID-19 era, and potentially see an uptick in this type of litigation.
Jennifer, I see that we have one question on the chat. Can we go ahead and address that?
Sure, there's actually two. One of them I was telling them we're going to do it at the end, so I'll read that if you don't mind.
Great.
When sending a cease and desist letter to the employee, I always warn to preserve certain evidence, particularly electronically stored emails, texts, etc. Do you recommend or recommend against sending a similar letter to the spouse of the employee who might have access to electronically stored data?
Sure, that's a great practice. I'm glad you mentioned that. I've never sent one to a spouse, but I don't see why I wouldn't if there was reason to. So especially if the spouse was involved in the business, or I had reason to know that they had information on some shared devices, or I thought maybe they were going through a divorce and I was afraid the spouse was going to hold something hostage. I don't know. But if there were facts to support that, I would do that. And on a related note, I'll just jump off that and say that if the question is often, do you send that letter to the employer, to the new employer, with the litigation hold language and whatnot? And it differs in every case, and it depends entirely on the business interests. Sometimes clients don't want to get their competitors involved, and sometimes they do. And there's different, in those letters, there's different levels of aggressiveness and friendliness. I think we've probably got 10 different versions of the cease and desist letter, depending on what the interests are. Sometimes you want to go in there guns a-blazing, and sometimes you don't. So, even sometimes, well, I can't imagine any time that you wouldn't want to put that litigation hold language in there, especially if you're sending that to an individual who that's going to be very surprising to, and that's going to cause them to become very alarmed when they see all that boilerplate that all of us lawyers like to put in about what you have to preserve and what you can't delete.
Thank you. We have another question. With the increase of mergers and acquisitions, have you seen continued employment in the new entity as a variable consideration for non-compete, consideration for non-compete and non-solicitation?
Sure. So, and the case is, the name of the case is escaping me. There's a case that's not that old from the Ohio Supreme Court that deals with mergers and acquisitions and whether non-competes will apply to the successor entity. And it's become very clear in Ohio that in most cases they do, and additional consideration is typically not required. Now, what I always tell my clients is I want to make sure I understand the nature of the acquisition. Was it an asset purchase? Was it a stock transfer? What exactly did we buy? So that if there's any concern that additional consideration is needed, we make sure that you get that additional consideration. So the bottom line is if you're on the front end and you're advising the client, then get the additional consideration. But if it's already happened and you've been brought in, you've got very strong arguments to say that additional consideration is not needed.
Okay, not seeing any more. Thank you both. You did a great job particularly with the technical problems we had, but we made it through. Thank you to everyone who attended today. You will get an email with a survey in it that you have to answer in order to get the code for CLE credit. But please tune in next week. Jack Moran will be talking about Ohio Revised Code 4112 and the Family Medical Leave Associational Discrimination under Ohio law. See you on May 13th. Have a great afternoon. Thank you.
Thanks, everybody.
Thank you.